Hi, my name is Kim Cullen, and I'm a personal injury attorney in Winter Park, Florida. A lot of people hear the word subpoena used when people discuss legal cases, so I wanted to take this chance to provide some free information to let the public know exactly what a subpoena is, what it does, or what it can do in the scope of litigation, and what someone should do if they happen to be served with a subpoena. So a subpoena is used to essentially command or demand that somebody who's not involved in a lawsuit either come to provide testimony in a lawsuit or provide documentation or information in association with a lawsuit. So many times we use a subpoena to gather records that might be relevant to a case that we're handling. For example, in a lot of automobile accident cases that we handle, we're curious about the cell phone usage of the defendants. Were they using the phone at the time an accident happened, or were they, who did they call after the accident? Information like that. So a way that we can get that information, if the defendant himself or herself does not have the information, is to subpoena the phone company for records. So typically we prepare a subpoena, it's served by a process server on the corporation, and then we wait to get the information back. Now, the corporations sometimes play games with us, and sometimes we have to have hearings about subpoenas and whether they're appropriate, or whether the scope of what we're looking for is appropriate. And also defendants can argue about subpoenas and try to convince a court that what we're looking for is not relevant, or it's overbroad, or something like that. The other kind of use of subpoena that we often see used or use ourselves in cases is subpoenas to make somebody come appear for a deposition, which is giving sworn testimony in a case. So again, the process server will go out to this person's house or whatever information or address that we have for them and serve them with papers and command them to appear for a deposition. Sometimes we ask them to show up with paperwork, and sometimes we don't. Sometimes they just show up and give testimony. Now, if they don't show up for the testimony, or if they don't want to show up, sometimes they call us and we are happy to reschedule for them or make things more convenient. But if they just don't show up or tell us that they have no plans to show up, then we have to go to court and have a judge order them to come to a deposition or appear for testimony. Or maybe sometimes the judge won't order them if the judge thinks that for some reason we're bugging somebody or harassing them or something like that. So a subpoena is very useful in a lawsuit. If you ever get served with a subpoena, don't ignore it. Take it very seriously. If you have a lawyer, if you're in a situation where you have a full-time or a lawyer that on retainer or something like that, I would turn the subpoena over to your attorney and let the attorney advise you about how to respond. If you don't have a lawyer and you get served with a subpoena, probably the best thing to do would be to call the attorney's office, find out what they need you for, or what they need the information for, and then decide yourself what kind of response you're going to make. If you have any questions about a subpoena, whether you're a client of ours and you want to know if we can use subpoenas to get information in your case, or if you've been served with a subpoena and you don't know what to do, you can always call me or my partner Robert Hemphill at 407-254-4901, and we're always happy to help.